The will means absolutely nothing if the assets aren't lined up to be part of probate and go through that process. Hi, Jeff Mersace, the Plain English Attorney, and today we're going to review something that's pretty basic, but not a lot of people understand it. We're going to talk about what does a will cover, what does a trust cover, what ends up in probate. And it does get to be confusing, and well, okay, that's just the way it is. A lot of people assume, oh, well, I can just have a will, or I can just have a trust, and it covers everything automatically, and that's not really the case. So first, let's go ahead and dispel one myth that is persistent and is out there. Oh, I have a last will and testament, and therefore my estate avoids probate. That's about as wrong as you can be. A will is your last will and testament, says here's what happens to my assets that end up in probate. Here's who the executor should be to handle the will. Here's the division of the assets, and are there any age limits? Are there any other stipulations? Once the assets get through the probate court process, here's where they go. So it's not avoiding probate. In fact, your last will and testament is your ticket to probate. All right, well, what about a revocable living trust? Because this is also a fallacy. Oh, I have a revocable living trust, and just because I signed that document, it means none of my assets end up in probate. That's also wrong. The way to look at a revocable living trust is if it were a suitcase. Best suitcase in the world, going to solve all your problems when you're going on a trip, but you can't just grab the suitcase, go to the airport, get to your destination, open the suitcase and go, well, there's nothing in here. This is a bad suitcase. No, 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 no. You have to make sure that your assets are lining up with it. That's what today's video is about. How are assets supposed to line up with either of these two legal documents so the documents control it? The will is if you want it to go through probate. The revocable living trust is if you want it to avoid probate. So let's go ahead and jump right in. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. So let's talk about a fictional case. Let's just say this is John Smith. John's got 3 kids. Mom and dad are still alive. And there are a couple of charities that John wants. So he's got a will. All right, so he puts together this last will and testament, goes to an attorney, doesn't really discuss any of the specifics. Oh, I need a will. Okay, fine, here you go. And the beneficiaries are 20% to child 1, 20% to child 2, 20% to child 3, 10% to mom, 10% to dad. And then he's got charity 1. Okay, I want 5% to go there and 15% to go to second charity. And by the way, the kids are still kind of young. I want an age limit of 35 placed on any inheritance that they may get. So that's what's covered in the will. Well, let's take a look now at the assets that John Smith has. John's got a bank account, actually 2 of them, bank account 1 and 2, a stock account, so there's investments and stuff in the market. There's a real estate 1, which is the primary residence, real estate 2, which is a rental house, an IRA, a 401k, and 2 life insurance policies. So, all right, John's got his will. Here are his assets. So naturally, all of these assets, when they go through probate, the will's going to cover it, and it's going to go exactly the way he wants, right? Not so fast. Let's move back and take a look at these assets one at a time. So everything is based on title and title transfers. That's an important point. When you really get down to it, probate can end up having really a lot of different downsides. There are really 4 big downsides. 1, probate is expensive. Generally, it's eating up somewhere between 4 and 10% of an estate. It's usually for attorney's fees and whatnot, but also appraisals and other things that cost. It takes a long time to get through the probate court process. 6 months to a year and a half, and 6 months is really kind of being generous. And it really is nothing for an estate to go 2 years or more. All right. Third big downside, it's a loss of privacy because all of the assets that go through probate have to be listed. What's the date of death values? Where were these accounts and the assets? And then who are the beneficiaries? And we need to list their name, addresses, and ages. Right? All that becomes part of the public record, and therefore that privacy is completely lost. And the fourth downside, don't want to get too much into the technicalities of it, but it's easier to contest a will in probate as opposed to something like a revocable living trust. When it's not part of the probate process, they actually have to file a lawsuit against the trust. So it's a little bit different. So those are downsides, and which is why a lot of people want stuff to be taken care of outside of probate. But with all those downsides, when it really comes down to it, an estate is nothing more, that probate process is nothing more than a massive, expensive, time-consuming, frustrating, and public retitling process. It's about retitling the assets over to the beneficiaries. So that should be pretty easy, right? It's simple. The will covers all of it. No, it doesn't. So we have to take a look at all of these accounts and assets one at a time. The problem in the U.S. is about 70% of the population has absolutely no estate plan whatsoever. None. And so as a way to help with this, these different accounts and assets could potentially have a joint owner with a right of survivorship, or it could have a pay-on-death beneficiary listed. And that's what's very, very typical with bank and stock accounts and retirement accounts and life insurance. It's, well, people aren't generally doing their estate planning, so we'll help them out. But it doesn't end up being a coordinated plan. So, okay, bank account 1 is payable upon death to child 1 and 2. Oh, this was set up before child 3 came along. And now, okay, so bank account 1 is just going to child 1 and 2. Doesn't matter what the will says, doesn't matter what the beneficiaries are in the will. It's listing the 2 children as the beneficiary. Now, the second bank account, no beneficiary, no joint owner. And so, all right, that's covered by the will. So that bank account does get divided 20%, 20%, 20%, 10, 10, 5, and 15. So that does go according to it, but it ends up in probate. And an important thing here, age limit of 35. Check it so there can be a trustee to oversee that. If child 1 and 2 are, say, 20 and 18, and you wanted it held in trust until they're 35, well, because it doesn't go into probate, it's not covered by the will, those 2 kids get the money at 18. All right. The stock account. Okay, that was payable upon death to all 3 children. So that goes to them directly at age 18. Again, no trustee oversight because the trustee oversight is listed in the will, and the will only covers what's in probate, and that stock account avoided probate. Right, real estate 1 and 2, there's no beneficiaries, no joint owners. So, all right, that is covered by the will. So it goes through the probate court process and gets divided and held in a testamentary trust through the will. The IRA and the 401k, oh yeah, we listed all 3 children. So, all right, they're the beneficiaries on those retirement accounts. All right, and same thing for life insurance policies 1 and 2. So what do we have here? Well, what we have here is a lot of these assets going just to the kids. The parents are cut out. The charities are cut out. And so the will is really, it's covering that 1 bank account and those 2 real estate pieces. All the other financial assets have beneficiary designations on it. The will means absolutely nothing if the assets aren't lined up to be part of probate and go through that process. So a will is useless for assets that are getting transferred some other way to avoid probate. And this ends up having a very disjointed plan. So look, if you want your last will and testament to cover your entire estate, then all of those pay-on-death beneficiaries should be, quote, estate, so that it comes under the jurisdiction of the will. even though that does mean probate. Right. A lot of clients come to me and my firm to put together their plan because we are very strong advocates of revocable living trust in a lot more situations than a lot of other attorneys will say that it's appropriate. So we put together a revocable living trust, but then we have a lot of good educational materials on how to fund your trust to make sure your assets line up with the trust. Remember, this is a suitcase, and we want to make sure that it's as packed, as well packed as possible. So let's go ahead and take a look at the example with the revocable living trust instead. So now it's not a will, it's a revocable living trust. If we don't have these assets lined up, it's because it's all still based on title and title transfers. Now, the document that we don't see in this graphic, there's something called a pour over will. Right? Let me talk about that for a second. A pour over will. There's a lot of information that we've got in our freetrustcourse.com, and it's my book, Estate Planning Basics, same thing. The pour over will is a last will and testament, but just says, hey, if anything does end up in probate, send it to my trust to be distributed. So that does take care of an issue of the privacy part of it. So it's not going to disclose who the actual end of the line beneficiaries are. It's just going to list the name and address of the trustee. And believe me, I've seen this happen. There are marketing people who will go through the probate files and see who they should be putting on their marketing lists. Well, okay, they're not going to have the names and the address of the actual beneficiaries, just the trustee, so they'll tend to leave that alone. So that's how that works with the revocable living trust. But again, the assets all still have to line up with it. And that pour over will should only be for those forgotten items. Like, okay, I've got some instructions for someone to ship something to me if I forget it on my trip because I didn't fully pack the suitcase. There might have been one or two items. Well, what happens if all of these assets are lined up exactly the same way with these hodgepodge of beneficiary designations? What happens then? All right, so same thing, look one at a time. Okay, payable upon death to child 1 and 2 for that bank account. Second bank account, okay, it goes into probate, which, all right, it'll get sent back over to the trust, but because it wasn't in the trust to begin with, it's going to have to go through that probate process with all of the attendant costs and everything else. Stock account, yep, going to the kids, no age limits. The real estate 1 and 2, there were no beneficiaries, no joint owners, so it goes to probate. So again, it'll end up in the trust, it'll end up getting divided the way you want, but it still has to go through probate. The IRA, 401k, life insurance, going to those 3 children directly. So again, no age limits, no trustee oversight. It just goes to them automatically. And so once again, we're still cheating out mom, dad, and the 2 charities for the percentages that they were supposed to get. So what's the solution for a revocable living trust? You need to make sure that all of those assets that can end up being owned by the trust. Not all of them. Let's talk about the 2 exceptions in that list. The IRA and 401k. All right, that's tax-deferred money. So if you move that into the revocable living trust, it's going to cause the money to end up being withdrawn all within 1 year, and they say, okay, we want the taxes. So those 2 bank accounts that can be in the trust, stock account owned by the trust, real estate owned by the trust, IRAs and 401ks. All right, for IRAs and 401ks and other retirement accounts, there are really 3 options. I talk a lot more about this in my trust funding course, trustfundingcourse.com, if you want to take a look into it. But for things like that, you've the 3 options. 1, you can name the trust as the beneficiary. All right, that's got certain tax consequences. If you name the beneficiaries directly, that's option 2. There are actually some better tax options that are available, but no trustee oversight. It doesn't go according to the full plan. Third option, we can set up very specific IRA trusts for the beneficiaries that need it. So in this case, it's probably going to end up being, I'll name the trust as the beneficiary. Again, those have their own tax consequences that go along with it, but it's a way to make sure that the plan works without probate, is making the trust the beneficiary. Now, life insurance, same thing. Make the trust the beneficiary. There's no difference in any kind of income or other taxes there. It will all get paid on death into the revocable living trust without the policy having to be owned by it. And now all of those assets would end up avoiding probate. Again, all those assets would end up avoiding probate, and it's going to end up passing pretty seamlessly in the revocable living trust the way it was meant to. But again, you had to pack the suitcase. So look, it really isn't as simple as saying, oh, I have a will, here's how all my property goes. No, you've got to check the title on each of these items and whether or not there's a pay on death beneficiary. And you can't just sign a revocable living trust and say, oh, everything avoids probate. No, it's the suitcase that needs to be packed. You have to check each and every item, and something should be done for everything that's titled to either be in the trust, payable into the trust, or payable to other people or entities specifically for tax and other purposes. So that's the way it works. It's not as simple as just having the documents, and it doesn't mean that it's necessarily going to avoid probate if you don't take these other steps. So I hope you found that clarifying information useful. This really is kind of a good place to start when you're thinking about whether you need a will or a trust and how would that work. There is some underlying work in looking at the title for these types of assets to make sure it's doing what you want it to do. It's not just the document, it's looking at the assets. So as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.